Mr. Lloyd, Miss Tate, will you concede that there is really only one issue in this case, and that is whether or not the men went up onto the bridge that night in defiance of express instructions? Mr. Lloyd, would you like to answer first?
My Lord, I really must concede that is the position.
Thank you. Miss Tate?
I agree that is the position, my Lord.
Yes, thank you. Members of the jury, before counsel address you, I should like to clarify matters if I can. The law is that an employer must take reasonable care for the safety of his employees. In addition, it has been laid down by Parliament that an employer must abide by certain safety regulations. Now, Mr. Lloyd, for the defendants, concedes that if the men were sent up onto the bridge that night after they had worked a 12-hour day and without safety nets and so on, then the defendants were failing in their duty to their employees and, in particular, to Mr. Stevens. However, the liability of an employer ceases outside the scope of employment. So if it is a fact that the men went up onto the bridge in defiance of express instructions, the defendants cannot be held to be responsible. Mr. Lloyd, perhaps you would like to go on now, would you?
Members of the jury, in an action such as this, the defendant is always placed in the unenviable position that in contesting the case, he may appear callous or unfeeling in the eyes of the world. This is, of course, not so. The management of the defendant company has as much personal sympathy for Jack Stevens as you or I. But the law only awards damages where there is fault, and for no other reason. Therefore, we must concern ourselves with the facts and with nothing else. And unfortunately, we've had a long, irrelevant debate on how accident-prone the company is. The simple facts are that over 10 years, it has a much better than average record on accidents. Over 3 years, a slightly worse one. We've had a long debate on Jack Stevens' real age, with the passing round of registers, 3s looking like 7s, etc. But the simple fact is that Jack Stevens was 48 years old when he fell off the bridge. We had a long, involved session on the safety belt shed. But the relevant facts here are that the company had met its lawful obligations by providing safety belts at the site, that no one on the night in question at any point asked Walker for a safety belt, and that no man was ordered to or forced to go up without one. It really doesn't take that long to open a shed. Which brings us to the central and the crucial point of why the men were on the bridge anyway. Now, this gang had a very strong charge hand and active union man in Mr. Morgan, who has fully demonstrated his volatile personality at great length throughout this case. And I maintain that it is absolute nonsense to suggest that Morgan's crew sheepishly went back to work because Walker had ordered them. Because I believe if a man like Morgan really was against going back to work, there would be literally no way you could make him. And I certainly wouldn't like to try. Yet it is a fact that he did go back. Now, could it be that whereas an order or a suggestion from Walker would surely fail, a taunt from Jack Stevens might succeed? Come on, little boy. The men are going back to work. Now let us ask why Jack Stevens actually fell off that bridge. The learned friend has gone to great lengths to show there was no gale on the night and that working conditions were therefore normal, so we know he wasn't blown off. It is a fact that Jack Stevens is 20 years older than his wife. It is a fact that Thomas Morgan regularly took out Mrs. Stevens. The exact nature of their relationship, I'll let you decide. It is a fact that Stevens rowed with and fought Morgan less than 24 hours before the fall. It is a fact that Stevens was seen rubbing his left arm, which later revealed torn ligaments. And it is a fact that despite this injury, he deliberately walked across the top of the girder rather than straddle it, the most dangerous way to cross. And it is a fact that within minutes of climbing that bridge, Jack Stevens had consumed enough alcohol to fail a police breathalyzer test. And it is a fact, regrettably, he fell off the bridge. I submit that this accident, however tragic, was hardly solely the company's responsibility, nor caused as a direct result of their negligence. So I must ask you, on the facts, to reject the plaintiff's claim.
Members of the jury, we have been told that statistics prove that £1 million worth of business cost the life of one man. A cold, hard fact in this high-risk business. But we cannot dismiss the plight of Jack Stevens so simply. He is not a statistic, but a helpless shadow of a man, now totally dependent on others for the rest of his life. We have heard numerous versions and reasons for this accident, but I ask you now to consider just these few basic things. Firstly, Porton was under great pressure to get that bridge finished. It was behind schedule, and the penalty clause we now discover was not covered by any indemnity, a fact that Mr. Porton had strangely forgotten in the court. Secondly, he stood to lose control of the company if another loss was shown. And thirdly, the gale warning. Now, whether he genuinely believed this or not is not the issue. What is important, that his concern for the project was such that he saw fit to visit that site at 8 o'clock at night. Now, members of the jury, if you were in his position, would you have been merely disappointed that the bridge had not linked up? Or would you have rather tried to do something about it? I put it to you that pressure was put upon these men to return to work, whether directly or indirectly, although they were ill-prepared to do so after a 12-hour shift. It is my submission that Porton Construction Company is morally responsible for this accident and should compensate the victims accordingly.
Members of the jury, you have now heard the evidence of both plaintiff and defendant. And while this has been most ably presented by learned counsel, it has also been conflicting to a degree. Many issues have been raised, some you may consider to be irrelevant, others more important. However, as I have already told you, there is really only one issue for you to consider, and that is whether or not those men went up onto the bridge that night in defiance of a direct prohibition by Mr. Walker. In other words, who is lying? Is it Mr. Walker, or Mr. Porton, or Mr. Morgan? Because it is sure that only one of these men can be telling the truth. And when you choose between the evidence of these three men, remember their demeanor in the witness box and ask yourselves who was honest, who prevaricated, whose evidence on all points had the ring of truth about it. I must remind you that in a civil case of this sort, the burden of proof is on the plaintiff. So if you have difficulty in making up your minds on any point of doubt, it must be resolved in favor of the defendants. Will you now retire and consider your verdict?
All stand. Members of the jury, will your foreman please stand? Just answer this question, yes or no. Have you reached a verdict upon which you are all agreed?
Yes.
Do you find for the plaintiff or the defendant?
For the plaintiff.
Is that the verdict of you all?
Yes.
Jack Stevens was awarded £35,000 in damages. Next week, a chance to join another jury in assessing the facts when our cameras return to watch a leading case in the Crown Court.